the counter claims, the two opposite parties have to be responsible for the respective expenses limited to the claim the counter claims. I don't know if this is clear. I would like to add very small details about the initial presentation. Probably just for a little mistake, you mentioned even players about the possible persons that are submitted to these rules. This is not true, because exactly to not limit the possibility of individuals to appeal in front of CAS, these rules have applications or have application only for what concern federations, member federations and affiliated federations. That means that a player had no at all necessity to submit bank guarantee to appeal in front of the CAS. So it's clear that an individual usually has not sufficient economical resources to submit a case in front of the CAS. So in this, for an individual, just usual CAS rules have to be applied. I don't know if I answered your question.
Yes, I just want to confirm that I misspoke there. It's only if it's a member federation or affiliated organization that these disclosure of funds and the security for costs provision apply. Sorry.
Thank you. Dr. Kali.
Thank you very much, Mr. Chairman. I have a serious problem with the note to 2.1. The last sentence. My understanding is that we are here talking of feed structures, and my bone of contention is the enumeration of the name there. Much as one appreciates the input in the drafting of the statutes, but I have a serious quarrels with the specific mention of the and sentence. Because here I thought we are dealing with feed structure. And I think by perusing through the entire document, I don't seem to have come across any specific need. Therefore, I have a very serious discomfort with that. Thank you.
Yes, sir. Mr. Boxer.
Thank you, Mr. President. Speakers, Delegate of Jersey. 2 points of clarification, if I may. The first one, I understood that there to be said that in relation to the provision for security for costs in Chapter 13.5, that there is intended to be reciprocity, that the same provision should provide for both FIDE and any other parties. I couldn't see the reciprocity provision.
That's correct, there is no reciprocity in that provision. The reciprocity is on the final decision on costs.
The other second point is related to the last comment. In the other elections, the provision in Chapter 4, Article 2.1, to do with the appointment and nomination of vice presidents. 2.1 provides for a minimum of 3, but it doesn't go on to say a maximum of 5. I wonder whether that was an omission.
Graham, where is this? Is it in the statute?
Yes, 2.1. In Electoral Regulations, Chapter 4, other elections it says 2.1. The General Assembly shall confer or reject the proposal of the elected president to nominate and appoint vice president.
Yes, this is a clerical error that you're entirely correct.
Any other question? Yes, Janus.
One qualification regarding proxies, that no other formal elements are necessary or for the validity of the proxy. So till the end, what? So no other formal, but what formal elements are still necessary? Is a stamp, official email, or something?
Sure, it must be in writing, it must be a paper, and it must be either signed or sent by the delegate or the president. Those are the only formal requirements. So it doesn't need to be notarized or anything like that. A delegate can send an email and attach a Word document with his proxy, and it doesn't need a signature. The president can do the same. Or the delegate can just hand-deliver, for instance, a proxy with a signature on it. Both will be accepted. Is it clear?
Yes, because it's a sensitive thing, and not to avoid bad jokes, let's say, false proxies.
Well, I think if there were an allegation of forgery, that would be decided by the Electoral Commission. Of course, if the signature is false, then it doesn't count.
Yes, also this formal elements or the way of delivering, coming from the official email or a fax, something like that.
It has to be something, yes, that makes it recognizable that it's the delegate or the president sending it, which a fax, if that were a personal fax number, that might be acceptable, but I think the idea is more from the email address from the delegate or the president.
There is another question, please.
Okay. It's regarding the proxy again. The proxy issues, it is a wider, complicated issues. If you will interfere, or the video will interfere in these issues, that a proxy should be limited to one proxy holders. This could be disputed by other FIDE members. FIDE members, if it gives proxy to somebody, another members, he has the consent to change their proxy to be given to another member. You got my point. My point is that any FIDE members hold more than one proxy, he shouldn't have the right to transfer it to somebody, FIDE members.
But this was a rule that was in the statutes before. This is actually not a proposed change. It's a proposal to keep the rule that a delegate had only one proxy. Somebody told me the history of that rule, but I think Marco might leave that.
No, it's many years this rule. It's not new.
Yeah.
We're not changing anything here.
Okay.
This is the old regulation.
Okay.
Yes, I would just like to touch on the point that was raised by Mr. Kutali with regards to note 2.1, the indication of a name within the statutes. I think that is, in my view, irregular. And also, in terms of she's been addressing us, I missed the point. Is she addressing us as counsel for FIDE, or in what capacity is she addressing the LDs?
This moment she's addressing it as one of the people that she has been working very hard to reach this level.
No, but for record purposes, is she...
we have not hired her on this.
Because she's addressing the delegates. I think that...
Yes, I asked her, because we have been working with her many hours, many days here. She knows very well all these points. That's why I asked her to really explain the point.
I appreciate that. I think that for record purposes, I think that the delegates need to know.
She's a lawyer.
Yes, she's a lawyer, yes.
She's a lawyer.
Is she addressing us as a lawyer for...
Yes, as a lawyer.
For FIDE.
What's mean for FIDE? Yes, for all of us.
No, but I think for the record, it needs to be recorded exactly.
Okay, she's addressing for all these member federations. She's trying to help all these member federations. Now, on your point, I will ask Kisa to clarify that you nominate Mrs. Aung Sanders, 2 more people. I can even immediately after this, I will ask him to nominate so Mrs. Aung and 2 more people, and so we take your name. We nominate, but we take the name. Okay. They are right, that's okay. Yes. We agree on this. You could stay in the history.
Okay,
there is any other question?
Yes, second point that the lawyers or the changes recommended that words should use reasonable in many places. a word reasonables in a constitution or a statute, word is subjective to unlimited power given to a person who has the authority to practice at his chair or as a position. So I think reasonable as a word itself, it gives power to a person to use his authority with unlimited border. Thank you.
Is this about word reasonable in the CAS provision? I don't think it is located anywhere else. Just to explain, in the CAS, like in any court where you go, you will have your debate on the merits, and then the judge at the end of the case will decide who must pay the costs. It's, if you go to court in any country, that's how a judge does it. He first decides the case on the merits, and then at the end of his judgment, he will explain, you have to pay X to Y, or each just bears their own costs. It's a decision that is made by any decision maker. And it is also the way it is always done in an arbitration. When you agree to have your disputes resolved by arbitration rather than by going to court, you will go before a panel of 3 arbitrators, and the arbitrators will, like a judge, decide the dispute on the merits, and then they will also decide on the costs. It's natural, you have to make a decision on this. Should one pay for the costs of the other or not? And so the only thing that the reasonable does here, absolutely, it gives the discretion to the arbitrators to decide what is reasonable, like any judge has to do in any case. So it's a discretion, but it's a good discretion because it gives the decision maker the power to say, your cost for $1 million, but I think this should have been 800,000, I'm only going to grant 800,000. And it's a protection for the party that's bringing the case because you do not control how the other side conducts their defense. And it would be unfair to be held reasonable for defense, to be held liable for defense costs that are just not reasonable. So that's the intention.
Thank you, Mr. Dukan. Can I ask you something? Are you a lawyer? Because I have a feeling that we are a lawyer and we miss you in the meeting. We could really have you there.
Thank you, Mr. Chairman. I'm just quickly making a follow-up to the point raised by Mr. Mube. I think FIDE, as an organization, has a reputation, has integrity. And much as I respect your choice of requesting Mr. Santens to address us, I think to me it's something that goes a long way in compromising and undermining our integrity as an organization. First of all, I believe that FIDE has legal representation. And again, that act alone speaks volume in terms of our inputs in the statutes. Are we saying we don't have anyone within the FIDE structures, including representation, who can clearly articulate issues that were raised during the discussion? I think this undermines the integrity and reputation of FIDE. And in future, let us look carefully at such issues. Thank you.
You know, I have a serious comment on this point. You know what is this problem of this organization the last years? It's the lack of trust between FIDE members, FIDE officials, delegates and FIDE officials. This is a serious problem. What I believe is maybe first time for many years now that we reach a situation that we can feel that no one is out of the family. After this hard work that has been done here and all this month, I cannot say personally that Mrs. Santos is out of the family. Of course we have our lawyer, and we trust our lawyer. I did it especially to show that we don't feel at this moment that Mrs. Ang is out of the family or Gary Kasparov is out of it. It's the first time that we have reached such a really good spirit in FIDE. That's why I was asking from the beginning to think very, very serious that we should keep this spirit. You should help us to continue like this. And this is much more important of who is our lawyer and who is not our lawyer. Of course we have a lawyer and a very good lawyer. Thank you. Jeffrey.
Actually, Dr. Jean-Marc Raymond is sitting behind Vittoriano, so I mean, the FIDE lawyer is present, and I'm sure that if he wishes to comment, he will do so in due course. But exactly as Mr. Makropoulos has just said, I mean, the principle is one that there's been a lot of work being done in the background, both officially and unofficially, to try and reach a compromise so that we can move forward and have a better FIDE. You know, the objective of these statutes are so that we can avoid unnecessary quarreling about other things and start to build, you know, where we want to go. So realistically, Dr. Angst has just explained, you know, the principles, the key underlying principles. I don't think we should be looking, you know, for tigers. There are going to be items which will crop up nevertheless in the future, and we will solve them as, you know, one organization. I think what Mr. Makropoulos has just said, we are proposing this as one organization, which is a very big step forward, and we should just endorse it. Okay? Thank you.
Professor Newk first.
I'd like to make a remark on about the whole procedure. We are here in a situation began 2 years ago around the Congress in Khanty-Mansiysk. And the events in Khanty-Mansiysk and what happened before and above all later in Kars, in Lausanne. That is the root of our problem, of the chess political problem we are confronted with. And the FIDE leadership felt also that it appeared it was necessary to go over the statutes and to amend the statutes in several points. And federations were invited. I have to remember Mr. Our president who invited all the federations to make their inputs about renovating FIDE, not only the statutes, also technical matters. And a lot of input that come in, and in technical programs also, we should see in this assembly that in commissions improvements will be proposed and hopefully accepted by the General Assembly. So our question of today is the political matter. And FIDE is a democratic organization, and we have to follow democratic rules. We are acting in the General Assembly like a parliament. We are the World Chess Parliament. So in a democratic state, parliament cannot solve difficult problems in general sessions. This is not possible. So there are committees where negotiations go on sometimes for months, even for years, at least for weeks, to find a text, a solution, if there is a conflict between two or more parties. We are in a similar situation here in FIDE. There were at least, let's say, two parties, not political parties, two parties of interest, FIDE and an opposition to FIDE. And so negotiations began, and it is like in Parliament. If the problem is difficult, negotiations are very tough, of course, and they last until the last minute before the decisive assembly. As far as I was not member of the committee which drafted the final paper, but I know, and I was part of the commission which prepared these discussions, and I know that very serious people have negotiated very seriously for days and nights before our General Assembly today. So the whole thing is really now, this situation is a kind of trust, of confidence. We should have confidence from both sides, from several sides, in the people who really very seriously looked for a common ground. And I'm happy to say, my impression is, my serious feeling is that they succeeded in finding a compromise which certainly was not easily accepted, but finally it came out and it was submitted to our assembly here in our church parliament. So I would say, I would also say thanks to those people who were already, whose name were already quoted here. And I think time is really ripe to accept this common proposal so that you have a chance not only to improve the situation and the status of Philip, but also to go over in this Congress in Istanbul to chess matters. We are in chess.
Thank you. So there is a motion from Professor Ljungqvist to proceed with the approval of the status. So, who are in favor of approving status and electoral regulations in total without any changes how we have presented here? Please raise your hands. Those that they have two votes, raise both of them. Please raise your hand. Thank you. Who are against? Please. Who are against? 1, 2, 3, 4, 5, 6. Abstention? 1. The status has been approved and the electoral regulations. Thank you. We will break for lunch because I understood that there is a problem with the tax. Wait a moment. But before this, I will come to, I didn't forget. Let me explain you how we are going to proceed. When you come later, we have this Commission Financial Regulations and Language that there are some proposals. But Gary now, please don't leave anybody. He would like for 5 minutes to address the General Assembly. Please.
I think we must go back to no.
Mr. Chairman, officials, delegates, I really appreciate the opportunity to address the Assembly, and I have to congratulate all of you with, I believe it's a historic achievement. There was enough said about the importance of this moment, and after these 2 years of turmoil and fighting, which is probably, as a political background, but still after all this fighting, we came to a compromise that I believe will eliminate most of the grounds for grievances and for complaints. As all chess players, we know that when the game of chess is played, especially when a number of games have been played, there are mistakes made on both sides, and the good players should go back and analyze it and come back with good solutions and good strategies for the future. And of course, as chess players, we understand the importance of the rules that govern our game for centuries. And the fact is that we all recognize the inefficiency of the rules that have been drafted ages ago, actually in the previous century, and we worked so hard to make sure that these rules will apply to the demands of the 21st century, especially after strong recommendations made by CAS, by the Olympic Tribunal in Lausanne, which shows the adherence of FIDE and member federations to the principles of the Olympic movement, and I believe will improve our standing in the eyes of the IOC officials. Of course, it doesn't mean that we have no more differences. To the contrary, I'm sure there will be disagreements and there will be fights inside. So, yes, I may disagree with a number of elements in the current management. I may not like how, for instance, the Aegon contract that will be discussed here later was negotiated and drafted. But I think that's very natural. And we will be fighting within one family, and we'll be fighting for reaching goals of brighter future for chess. And I appreciate FIDE's emphasis now on education. I believe that alongside with our goals of joining the Olympic family as a full member, there's also a very important goal of penetrating the educational system around the world. In my belief, this is the real future of the game of chess, because that's where we have no match with any other sport, a mind sport or any other sport. Chess proven to be a unique educational tool, and it's in our power to prove it in all continents, in every quarter of the world. I've been working aggressively on that, creating the Kasparov Chess Foundation in the United States, in Europe, in Africa. I see a lot of work done by FIDE and member federations, and I believe that that's the real path to our success. And I would just to make this the final comment, saying that with all the differences, with all the fights that we'll have in the future, I believe that we have to concentrate not on the wrongdoings of the opposite sides, not looking for the sort of weak spots and criticism. Sometimes unfounded criticism, sometimes fair criticism, but I would rather see us concentrating on the positive notes. So the competition in FIDE should be based on the ideas, not on who did something wrong in the past, but rather who can do better job for the future. And we have great ideas, and I believe that fighting together, even if we disagree on something, for the better future of chess, that's a noble goal. So I will do my utmost in the years to come to prove that I have ideas that could make FIDE better, stronger, and more prosperous. And I hope that the spirit that prevailed in this room today will be guiding our endeavors in the future. Thank you very much.
Yes.
Break for lunch. 4 o'clock. We continue. 4 o'clock. Sorry. Yes, 4 o'clock. 4 o'clock. Okay, those are the good times.